Item number 1 to 4.
This, I believe, Mr. Paul is ready for hearing. Okay, pass over at the first call.
Item number 5.
May it please your Lordship. Lordship, as per the order dated 14/5/2025, we have filed a report, my Lord. But my Lord, I seek your kind indulgence, my Lord. One more districts we haven't filed. So, if my Lord permits, we'll file an additional report, my Lord.
Where is the report? Which district is not covered?
Lordship, East Janja Hills, my lord.
Good work they have done. You have received a copy of the report?
Yes, we have.
Do you wish to make any submissions?
My lord, I just submit that if you can give us some time to go through over the reports we just recently received it. That's all, my lord.
When you received the report?
On Monday, my lord.
Sorry?
Monday, 23rd.
Please take down. Order dated 14th May 2025. Paragraph, in terms of the said order, a report had been filed by the respondents, which we considered on 14th May 2025. A report dated 11th March 2025 had been filed, which we considered on 14th May 2025. We observe that action in terms of the order dated 16th August 2024 had only been taken in a major portion of East Khasi Hills district and not in others. we passed a detailed order directing the Deputy Commissioner heading a district to carry out awareness camps, make public announcement of the health hazards of the use of plastic, and for taking steps that single-use plastic items of less than 120 microns are neither manufactured nor are not cut out neither manufactured in this state, brought into this state from outside, or sold here in any manner, extensive inspection to discover any clandestine use of banned plastic and for taking steps against offenders. Today, today Learned Counsel for the respondents have filed a report stating compliance with our order dated 14th May 2025. Full stop. The report specifies district-wise compliance in 11 districts, except which one?
Lordship, East Jantia Hills.
East Jantia Hills. Learned Counsel for the respondents is directed to file a compliance report by the authorities in East Jantia Hills before the next date of hearing of this public interest litigation. Paragraph, we have perused the report. We are quite satisfied with the steps taken. Also, we note that within quotation, prohibitory orders have been passed by the district magistrate banning sale and use of plastic carry bags of less than 120 microns from June 2025. Now, you write this in this way. We find that the district magistrate, East Khasi Hills District, has issued a prohibitory order banning the sale and use of plastic carry bags of less than 120 microns from June 2025. We find that a similar prohibitory order has been issued by the District Magistrate, South Garo Hills, Pagmara. It appears from the submissions of learned counsel for the respondent that similar prohibitory orders have been passed in all the districts covered by the report. Moreover, awareness camps monitoring the use of plastic and appropriate measures against the wrongdoers seem to have been initiated. Full stop. Although the action taken seems to be at the initial stage, we direct that comprehensive action should be carried out to enforce the orders of this court dated 16th August 2024, read with the subsequent orders, the last of which was made on 14th May 2025. The respondents are directed to file a supplementary action taken report on the next date of hearing of this application. List this application for further consideration on August. A copy of the report is to be served upon the advocate on record for the petitioner.
Highly obliged.
Obliged.
Number 6.
She was given opportunity for the parties to explore the possibility of settlement, given time till today. We need some instructions.
My Lord, Advocate General is leading this matter. So, my Lord, what he has informed, I have a telephonic conversation with him, my Lord. We were informed by the counsel for the petitioner that they have come to a settlement with the government. However, my Lord, that was through verbal communication, my Lord. So AG has requested if the matter can be taken up after 10 days, my Lord, he will be taking formal instruction from the government, my Lord. Most likely.
Is he coming back to the
my Lord,
country?
he has actually requested Lordship to kindly have this matter after 10 days.
We were told yesterday that he is abroad.
Yes, my lord. Yes, my
Will
lord.
you be returning in 10 days?
My lord, yes. Only request, my lord, after 10 days if the matter can be listed.
At the request of Miss Colony, the government advocate for the appellant, this appeal and the connected applications are adjourned till 9 July
My lord.
to ascertain the result of the settlement
My lord.
effort undertaken by the parties.
My lord.
Number 7.
Ready for hearing?
Ready, my lord.
You are ready?
Oh, lordship. It can be taken next week, your lordship.
What do you say?
Next week, your lordship. Or any other day also, your lordship, except this week.
Why not finish it on Friday?
Friday, I have some
Always.
difficulty, your lordship.
30th
30th,
by
lordship.
consent of learned
Lordship, yes.
counsel for the parties. This writ application is adjourned till 30th June.
Deeply obliged. Deeply obliged.
Yes.
Number 8.
It
Yes,
is, Your Lordship.
Mr. General.
Lordship, parties in this matter are happy to inform this Honorable Court we've settled the matter amongst ourselves. My appeal has become
Well, what was the matter about? We heard it.
not really, my lord. It's a fairly new matter. It concerns my bank account. Respondent number 4, my lord, that is Maharashtra Police, had issued a direction to my bank to freeze my account.
Yes, the jurisdiction matter.
Jurisdiction matter.
Justice, thank you.
Yes, my lord.
Had ruled that this court had no jurisdiction.
In spite of the fact that the bank account was within the territory of this Honorable Court, learned single judge came to the conclusion that I
But
should
the investigation was by the Maharashtra police.
My lord,
was
yes.
conducted by.
My lord, I represent the investigating agency, my lord, Maharashtra Police. So, my lord, on the 2nd of June, my lord, we have issued a letter to the State Bank of India, my lord, in which the account of the appellant has been was freezed, my lord. So now, my lord, via this letter, my lord, we have requested the bank to unfreeze the account, my lord. If lordship may kindly have this.
No, if it is
So-
settled, you withdraw the appeal, finish.
I want to withdraw the appeal.
That's all.
I want to.
We are recording nothing.
Lordship would like to have this copy, my lord.
No. This appeal is not being proceeded with.
My lord.
My lord.
Mr. Jindal, learned advocate for the appellant, on instruction submits that his client does not want to proceed with the appeal. As the subject matter of the dispute has been resolved outside the court. We can record that.
That's all. That's all.
Paragraph. In that view of the matter, this appeal is dismissed as not pressed. Interim order, if any, is vacated.
Obliged.
Lordship.
Obliged.
My lord, I am put a respondent number.
Yes.
Second call, item number 1 to 4.
You will bigger because it is stuffy. Can you just lower the You're the appellant.
Yes,
Dr.
I'm
Motika.
the appellant.
Yes.
Wait, please. My lord, the story begins with page 22, my lord. This is the advertisement issued for the appointment, my lord. Page 22, my lord. This is the advertisement dated 10th July 21, issued by Northeastern Center for Technology Application and Research. Now, my lord, at page 24, you lordship will find the various posts, my lord. So these are signed.
What is the issue involved, Learned Deputy Solicitor General?
My lord, issue was, my lord, that this center, my lord, this is a nectar, which is an organized autonomous body under the Ministry of Science and Technology, Government of India, my lord. And it is governed by a governing council, my lord. The chairman of the governing council is the Secretary of Department of Science and Technology, Government of India. And there are other members, my lord, in the governing council. Now, for these particular posts, my lord, the appointing authority is the governing council itself. The governing council is chaired by the Secretary to the Government of India. And Nectar, as an autonomous body, my lord, there is a Director General of this institution, my lord.
Yes.
Now, my lord, rules provide that the appointing authority for certain grade of post, my lord, which are the posts involved here, is the appointing authority is the governing council, not the Director General, my lord.
Yes.
That's one aspect, my lord. Our case is that appointing authority is governing council, not Director General. That's one aspect, my lord. Second aspect is, my lord, in terms of the rules, these posts were to be filled up first through deputation, my lord.
Yes.
And only if suitable candidates are not available on deputation, only in such case, my lord, direct recruitment was permitted, my lord. My lord, it says, my lord, if I may just read one sentence, my lord. The posts, the priority on filling up of our post will be on deputation, including short-term contract absorption basis, failing which through direct recruitment, my lord. So, my lord,
Which clause you are reading?
my lord, page 26, if lordship kindly comes, my lord. Page 26 of the paper book. Clauses 1, 2, and 3, my lord.
Page 26.
Page 26, my lord, of the paper book. Clause 1, my lord, it says all the posts are proposed to be filled up on deputation, including short-term contract absorption, failing which by direct recruitment basis, applicants should refer the terms and conditions so and so. Clause 2, my lord, the priority on filling above the above post will be on deputation, including short-term contract absorption basis only. 3, my lord,
Page 26 top. There is another page number at the bottom. Page 3 of 5. Page 3 of 5. Yes. 3 of 5 down below.
well, page 26 at the top, my lord, is written by hand, my lord. All the posts are proposed to be filled up, lordship is got.
All the paper books, the pages are. Well, it's, some of the paper books, the pagination is a little different. I don't know.
26 top pagination.
Yes, my lord.
So this was placed by Mr. Paul on an earlier occasion. Now this kind of internal problem amongst you, like whether it is by deputation or by direct recruitment, Director General or Secretary.
My lord.
Now, is a third party candidate, he is supposed to investigate that and then accept service. Now, when he's been asked to participate in the recruitment or selection process, he assumes that the deputation candidates are perhaps not available, that is why I'm called. And then when he's given the letter of appointment, it is not somebody from the street who's giving the appointment. It's somebody having ostensible authority, Director General. Now, he is not supposed to probe into that, or he's supposed to take the ostensible authority as correct, or the presumption in the evidence law that what is done regularly.
That's
Then after that appointment is made, the person appointing has no authority. It should have been filled up by deputation. That is your internal problem. Now the persons who have been appointed cannot be made to suffer.
My lord, we are not putting any blame on the respondents, my lord.
No, but the effect of allowing the appeal would be terminating their service.
My lord, what we are praying for your lordship, my lord, that at the top level, my lord, a decision has been taken to scrap this appointment, my lord, and call for fresh advertisement. Normally, they will be at liberty to apply again, my lord. That is subject to what?
That would be most unjust. How long they are working?
Since 22.
It's 22.
Since 22.
Then 3 years.
In some substance, that's the only point in issue, my lord. Our case is, my lord, the Director
You
General.
would also, from your conscience, not support this kind of a thing. Dr. Mosika.
That's what I am doing, my lord. Well, I understand your lordship's query, my lord. I know where I stand, my lord. This is absolutely, I'm clear on that.
No, but you please help the court what to do.
My lord.
Because at once you will go to the Supreme Court.
Because what happened, my lord, what Director General did here, after issuing the appointment letter, they joined, my lord. Then he sent the matter to the Governing Council for post facto approval. Now, it is the case of the Governing Council is that it was not given any approval, and rather the secretary of the chairman of the Governing Council said that this is not proper, these appointments are not proper. It should be scrapped. A fresh advertisement should
Where
be
is the letter of appointment?
my lord. Page 125, my lord, is one of. Page 125, my lord.
125
Yes.
in my mind.
I stand correct, my lord. This is 21, November 21, not 22, my lord. Upon they are serving since 21, my lord. Page 125 is appointment letter in respect of one of the respondents, my lord. This is 11/11/21. Offer of appointments to Ankit Srivastava for the post of software engineer on direct recruitment.
125.
125, my lord.
It is the offer of appointment.
This acceptance was conveyed. Roman 9.
Yes, my lord. The next page 127, my lord. He accepted the appointment.
130 is
130 is the joining report, my lord. Page 130. But the problem started at page 136, my lord. Lordship kindly sees one.
Yes.
Page 136, my lord. My lord, these are the minutes of the Governing Council meeting, my lord, that was held on the 18th April 22. May I just read a few lines, my lord? At page 136.
One 136.
136.
Yes.
So, my lord, here after issuing the appointment order, the Director General sent the proposal to the Governing Council for post facto approval, my lord. Then the resolution says, my lord, GC was apprised about the recruitment process relating to Group A post carrying grade pay of rupees 6 so and above. The criteria mentioned in the recruitment rules and role of GC in terms of Rule 3.1 of the Service Bylaws of Nectar for regularization of Group A post carrying grade pay and so and above was explained in general for seeking approval of GC. Chairperson asked DG Nectar to clarify whether recruitment rules of Nectar as approved by the appropriate authority have been followed in the matter. DC Nectar assured the chairperson and all other GC members that RRs have been scrupulously followed and all the procedure. Selection of candidate has been made by the selection committee interview panel duly approved by the chairman Nectar in a transparent manner. Score sheet of marks awarded by the selection committee duly signed by each member of the committee is available for perusal and records. The scores of each candidates were displayed on the website of Nectar. Not a single representation from any of the candidates has been received in this regard. The offers of appointment were sent to the candidates in order of merit following the precedent adopted by Nectar in recruitment made earlier and approved by the GC as well. Further, the status of recruitment has already been brought to the kind notice of GC member through circulation by office letter number so and so dated 25/2/22 for approval for regularization of this appointment in terms of para 3(1) of service bylaws of Nectar and advised by DST by it under secretary so and so. Executive Council Nectar has already approved this recruitment during this meeting held on 21/2/22. It was informed that approval of 5 GC members, that is from Chief Secretary Meghalaya, Manipur, Nagaland, Sikkim and Secretary NEC, has already been communicated through correspondence. As such, approval of remaining GC members was also sought for in terms of provision contained in Rule 9 and 10, Part 3 of General Bylaws of Nectar. All the GC members endorsed their approval. Chairperson desired to place approval of GC before Secretary DST being Chairman of Nectar.
No, in the advertisement, was it mentioned that it is subject to approval of the secretary?
But subject to approval of the governing council, my lord. Not secretary.
Is it mentioned there?
But this is because that is the appointing authority for this post, my lord.
No, in the letter of appointment it was mentioned.
No.
In letter of appointment is not mentioned, my lord.
He is just asked to join, accept and join.
Lodge. As my fact says based on the instructions of the competent authority.
Now, my lord, thereafter, if I may just take your lordship to only one more page, my lord. But that is at page 174, my lord. The typed copy on the other side, my lord, 174. So, my lord, an inquiry committee was constituted to look into the matter, my lord, and this is the report of the inquiry committee, my lord.
Yes.
So, my lord, the inquiry committee's findings are, my lord, may I just refer to a few paragraphs, my lord. But small Roman 1, my lord. In terms of provisions as available in the recruitment rules of the post, the method of recruitment was by promotion, failing which by deputation, including short-term contract absorption, failing which by direct recruitment. Instead of first making sincere efforts for filling up the post on deputation basis, the vacancies were filled up by direct recruitment mode. That's the first concern, my lord. Second is, my lord, we may kindly come to Roman 6, my lord.
4, 4.
4, my lord. Issuing of offer of appointment, a letter letting the candidate assume charge of the post without the approval of the competent authority, that is governing council, is a serious lapse on the part of the institute. This is major procedural lapse which cannot be ignored. Rather, this committee is of the opinion that responsibility must be fixed as the appointments made were for Group A post, that too of level 11 and above. Then may I refer to 6, my lord.
How many appointments were made?
4, my lord.
5.
Oh.
5 advisors also.
Chief radio technologist.
Well, it's 5 made, 4 set aside, 1 is allowed to continue
Same procedure.
in the same selection procedure.
Same post factor approval. Please continue.
My lord, may I
And
suggest,
what has the learned single judge ruled?
learned single judge rejected our contention, my lord, and held that the appointments, they cannot say that appointments are irregular, my lord.
Where is the order?
My lord. Starts 176, my lord.
185 onwards is the order. Right.
My lord, may I suggest via media, my lord?
Yes.
Lordships direct the governing councils to take a fresh decision, my lord.
He will,
Without upsetting their appointment as of now, my lord.
he will straight away reject. You leave it to them, they will just like putting a person in a tiger's cage. They will finish off.
Lordship directs them to decide in certain manner also, my lord.
They will decide in the manner they have decided. They will not change.
By setting aside this, my lord, the impudence of Lordship directs us afresh. That will.
So with all due respect,
obviate
this
all
seems to be
the-
more of an ego tussle between two persons. Merely because Millets, the chairman was not present on that GC meeting, Millets, everything that has been done is sought to be undone. And Millets, why that appointment of respondent number, Millets, the 5th person is very important is, they justify it saying that since the chairman was part of the selection committee, so that does not need to be touched. There's a finding recorded to that extent by the Lansing judge.
What reasons the learned judge has given?
I'm sorry, Millets.
What reasons the learned judge has given in allowing the writ?
Well, it's para 9 of the writ petition, page 187, Millets. Finding is, Millets, at para 9, the finding is that GC is approved it.
But the basic finding is that the presence of chairman of governing council is not necessary, my lord. Well, what happened, my lord, one particular day, the ex officio chairman of governing council was absent, my lord, the secretary of department. Somebody else was chairing the meeting, my lord. The learned single judge held that it is by majority of the governing council, my lord. Any particular officer, whether he is present or not on that particular day, will not make any difference.
Well, because the rule says so, Millets, that nobody, but the chairman does not per se have any veto. If the general council has approved it, Millets, he has to approve it. Only difficulty, as I said, Millets, is an ego tussle on that relevant day that gentleman was not there. And that's why, Millets, the 5th appointment becomes very necessary, because that is justified saying the chairman was part of the selection committee, so it does not need to be touched. Very unfortunate, Millets, that this litigation is
Even one goes to a police station. There is a room which is not IC, inspector in charge or officer in charge. He sees the officer in a uniform with a star on the shoulder, badge on his front with his name written, etc. And he records the FIR. Now, is a person who is going to do that, lodge the FIR, to investigate whether he is the real IC or he is an imposter or he has the authority or he is just a constable wearing that uniform and taking that is the ostensible authority, and which is also recognized by the evidence as presumed to be done regularly, unless that presumption is rebutted by your knowledge.
Well.
So he is getting the appointment letter from the Director General. It is not written there. These things are something different. The chairperson is there or not. He is not supposed to look into all that. He is getting from a proper authority, Government of India, sealed and signed by the Director General. That is enough for him. You tell us, Learned Deputy Solicitor General.
But as only such
Now, if there is internecine dispute, like he has the authority, he doesn't have the authority, that is in the department. Was he ever so caused? The Director General? Any steps taken against him?
there's only a recommendation in the inquiry matter to fix the responsibility.
Nothing done.
Nothing has been done.
But the matter
Now
is sub judice after
these 4 persons will be made scapegoats because they want somebody else to come in. They have already decided on those persons.
It's not fact, my lord. Here what happened, my lord, most of them, they were already serving on contract basis, my lord, in the same organization, my lord. So when the advertisement came, they applied, my lord, and this is how. They were there in that, except one of them, my lord. Most of them were already there in contract basis.
What is the finding of the learned single judge?
I'll just refer to para 9 of the judgment, my lord, at page 187, my lord.
9, 10, 11, 3 paragraphs.
9, 10, 11, 3 paragraphs only. It's page 187.
The appointment of the petitioners, page 190, which are neither illegal, last 3 lines,
No, let's.
or irregular, are liable to be reconsidered.
Another 13.
Para 13.
What is this letter? 7/10/22?
This is the letter by which, the recruitment process was set aside. That was what was impugned.
Is it there in the paper book?
Yes, my lords. 7/10/22, my lords would find at page 149.
149.
Page 142.
149, my lords. Note this into order. Cancellation of appointment imposed was documented.
So what is the situation now? They are working or not working?
They are working, my lord.
We're working.
Because the learned single judge allowed the petition, my lord. So they are continuing in their post.
All right. You would like to add anything?
It's just one thing.
Yes.
Para 12, the learned single judge otherwise also holds, my lords, the basic principles of natural justice in addition to whatever else, having been adhered to, also would have required this order to have gone. Because admitted positioners, there was no notice, no nothing, my lords. One fine day we are informed that the recruitment process is set aside. And our appointments are gone.
My lord, in case number 4, this particular petitioner respondent, he had to resign from his earlier post where he was working in Meghalaya Basin Development. He resigned from his earlier post to join in this post on being duly selected. And my lord, as per the general rules, service rules of Nectar also, it is the Director General who is the competent person to issue any contract agreement, service agreement. So otherwise also, if it was with the approval of the General Council, the appointment letter would have to be issued by the Director General only in these cases. And besides, the minutes of the 8th meeting, where the post facto approval was given by all the General Council members, that minutes have been again confirmed and approved in the 9th General Council meeting. In that, no such objection was raised. They have approved.
Which is your appeal number?
Mine is
Item 4.
item 4, my lord.
What appeal number?
WA 15, my lord.
Rakesh Sharma.
15.
WA 15 of 25.
Left employment with
Meghalaya Basin Development.
Meghalaya Basic Development.
Basin Development. Basin Development Authority.
Basic Development Authority or what?
Yes.
Basin Development.
His resignation letter is also enclosed with the paperwork at page 145, my lord.
Yes.
And your lordship, in page 1.
No, you said something else also.
Yes, that 8th General Body meeting, it was in the 8th GC meeting which was held on 18th April 2022. The ex post facto approval was given by all the General Council members. And the minutes of this meeting was again confirmed and approved by all the General GC members in the 9th General GC meeting, which was held on 18th August 22, my lord.
That, my lord, would find at page 141 of this paper book.
And
the 8th General Meeting?
8th, my lords, would find at page 135. This is dated 18/4/22.
This is ex post facto approval.
approval was given by all the General GC members. Well,
And 141 is confirmation of those minutes.
My lords, it's ratified and adopted.
under item number 1, my lord, in that 9th General Council meeting, confirmation of the minutes of the 8th meeting of the Governing Council. The minutes of the 8th meeting of the GC were read, confirmed and adopted, which includes the
Secretary.
Confirmation of the ex post facto approval. Now what they have taken up was, after they completed all the agendas, under item number, if any, under that they have taken this decision under 9th General Body GC meeting. This was taken in the 9th meeting under item number 14. Any other item with the permission of chair. After confirmation.
After confirmation.
After confirmation.
In the same meeting.
In the same meeting. After confirmation of the 8th GC meeting minutes, confirm, adopt, accepted and adopted. This is under item number 14. Any other item with the permission of chair. Under that they are taking their recruitment process update received from ministry, and this they have taken the decision. So this also has been observed by the learned single judge in the judgment. That once it is accepted, adopted under item number 1 already, how could that is only under any other items. It could not have been again taken this decision under any other items.
And where in the rules it is stated that Director General is the proper authority.
That is not in our paper. You have copies of the rules? Ma'am, we have copies. I hope you're referring to this one. You're referring to this? Service rules.
Service rules copy?
Service rules.
Service rules.
Copies for the court.
This is the general bylaws, service bylaws.
Ma'am, this one. We have copies. You give it. You're referring to me? These are the general rules, no? The general rule. Rule 9 would be the relevant rules of the general rules. Court must.
Should be general.
Same, general rules, rule 9.
This one. Not in
Well, general rules, rule 23, where under the powers and duties of the Director General, part 5, powers and duties of the Director General, in rule 23 it says, subject to the provisions of bylaws 20 above, the Director General shall be competent on behalf of the Centre to execute contracts, collaboration agreements, general and special instruments, and service agreements. So it is within the power and duty of the Director General to sign any appointment.
Which clause you are reading?
My Lord, General Bylaws, clause 23.
Well, it's the court master is not placed in the bylaws.
So, my Lord, in other ways also, had it been when with prior approval or post facto approval, in any event, it would be the Director General who will be issuing the appointment letter. It is not that he is not an authorized person to issue the appointment letter. And the rules nowhere says the appointment has to be with prior approval. Had there been anything that it has to be with the prior approval of the General Council or anything, then they could have made out a case. But it is not a requirement that prior approval is necessary. So ex post facto approval has been given, and in the 8th general body meeting, GC meeting, my Lord, it has, while director was apprising the members, it is reflected that such precedents are there in Nectar where post facto approval has been given by GC. It is recorded in the GC meeting of the 8th GC meeting. And this has not been negated by any of the council members. And these GC council members who has given post facto approval, my Lord, they are chief secretaries of the different states. Such high-ranking officers, responsible officers, who has given this ex post facto approval to this action taken by the Director General. And what prompted to constitute the inquiry committee, no show cause notice was also given to the petitioners.
Where is it that subject to approval by the governing council?
It is not written but subject to. It is not written, and it is not required also under the rules here.
All right. So we are reserving judgment?
No.
Hearing concluded, stop CAV. Usual advocate on record for the parties in submission before the master attached to this court. Take 1 week.
Signed.
Your Lordship, I have had some case laws, my Lord, on that fact. At best, it can be said that it is irregular but not illegal appointment, because they have not challenged the recruitment process, screening process, or constitution of the selection committee.
You see, irregular, illegal, you are going into that Uma Devi, which means that it is a kind of a contractual appointment. You are asking for absorption. That is negating your case a little bit. Your case should be, as I have understood, run by Mr. Paul, is that this is an effective regular appointment.
Regular appointment.
No
yes.
question of regularization,
No.
because it is not illegal but irregular or etc.
Finding in
etc.
para 13, as the Lordship
Yes.
pointed out.
It is not. It
No,
is
that
not
is
under
single judge was appointed.
para 53 case. Para 53 of that.
Well, it's,
Yeah.
But if you wish to that, it would be your alternative. We can't stop you.
No, Your Lordship was also highlighting that single judges, that what single judges observed also, that it was not irregular or.
All right, you please include that in your notes.
Well,
That Umadevi principle. That's all.
Yes, that's it.
Because your other side also should know which case you are referring to in the notes. Otherwise, he will be taken by surprise. So that is the only thing you will mention in your notes, additional. All right.
No.
Written notes by 2nd July.
2nd July.
Obliged.
My Lord, before your Lordship rise, my Lord, two matters were kept reserved for judgment, my Lord. One, I am required to file written submission today. One was last Monday, my Lord. I could not file. I am filing.
No, the judgments have are under preparation. Nothing final has been done. You file your notes. You send them.
Highly obliged.